Hello, everyone. My name is Ben Williams. I'm a Texas broker in El Paso, Texas. I run a team called the War Team. And every other Friday, we do this thing called Friday Forums, where we break down the form with our agents and just unpack everything we can. And we're going to jump into this form today. Today, we're going to be doing the addendum regarding fixture leases. So we have people in our audience and we have people that's on our Zoom. So this is a live training sessions. There's going to be questions and things like that, but it's all good. Sometimes this gets long, sometimes it's short. Never know what we're going to have, right? So that being said, the TREC form 52-1 is the addendum regarding fixture leases. You use it when something is attached to a property and is not owned by the seller. The seller is leasing it. They're renting it. If you find out anything that is attached to the property and it's not owned by the seller for whatever reason, and they're leasing it, this is the form that you'll use. Sure. What's going to happen is the buyer going to have it or not have it, or the seller's going to remove it. This is what this form's going to unpack. If it is lease, we have to decide, is the buyer going to assume it or the seller is going to remove it? That's what this form is for. So let's jump into it. All right. So section A. Section A is titled the lease fixtures. It says, well, I'm not going to read what it says. I'm going to tell you what it means. Basically, if the seller don't own it, they can't transfer ownership at closing. All right. If they don't physically own it, they can't automatically transfer that at closing. They have to get permission for that. They can only, the only thing they can transfer in the lease if the buyer agrees. So if a buyer does not agree to this lease, then it can't be transferred either. All right. So they got some, if you look at there in section A, it already identifies solar panels, propane tanks, water softeners, and security systems, because that's the most common. But there's other things that could be attached to the property that they don't own that they're leasing. I just put one example that we had recently with another transaction. We had the charging systems for the cars and stuff like that for the electrical vehicle. All right. So that's something that we just had recently with a agent of ours, and they were leasing the electrical vehicle charging system. So it doesn't have to just necessarily be solar panels, propane tanks, water softeners, and security system. It can be anything that's attached to the property that they don't own. So keep that in mind. That's when they leave that section blank. Okay. If you go down to section A1, it simply means that the seller is assigned the lease. And if you look at it, it says, okay, hey, we're identifying these things like it before. And then it also says, if you look at the blank there, it says buyer shall pay the first blank. You should negotiate that. That's all negotiable, of any costs necessary to assume or receive the assignment of the fixture lease, and the seller shall pay a remaining amount. So let's just say we're starting this process and you're writing this out, and the solar panels, you could put in there $150. They'll pay up to $150 to assume the lease. If it's $1,200 to assume the lease, this is saying that difference between $1,200 and $150, the seller is going to come up with that. So on either side of this, if you're on the buyer side, maybe you want to cap that pretty low. But if you're on the listing side and you find out that the transfer to assume this is higher, maybe that might be higher. So you got to look at it from both lenses here. Or it could just be $0. The buyer's not going to pay anything to get this transfer going. That could be an option too. What you don't want to do, you do not want to not leave anything in there, right? This is not an NA. This is not, you need to put a dollar amount in there and cap it for whatever reason. It also goes on, and if you read it, it says buyer seller agreed to sign any documents required by the lessor in the fixture lease to assume or assign the fixture leases. So it's not just, this is not the only form that may be associated with this lease. Okay. So it may be some more stuff from the solar panel company, the propane tank company, and it's saying that you guys, the buyer and seller, is agreeing to sign whatever is necessary to assume the lease. That's what this document is also saying. All right. Now I got some risk down the risk point. If you don't fill out who pays, you could have a fight at closing. So you want to make sure who pays, all this other stuff is in there. Okay. Any questions about section A1? Yes.
So, just want to be clear. The buyer is going to assume her lien or whatever picture and you can company may provide a fee.
So let's say solar panel company A, whatever. They may have a transfer or assumption fee for this buyer to take it over, to assume it. We need to, hopefully the seller knows what that is. Hopefully the seller's like, okay, I'll pick that up. Shit. In my opinion, right? But they can cap that amount and say, okay, hey, the buyer, you pay 150 and I pay 150 to transfer this assumption, to assume this lease. They do have assumption fees.
Okay, that's what I'm missing. In my experience, I had not, I'm not going to say it didn't happen. It was just a part of assuming anyway.
It could be. It could be the company don't have an assumption fee.
Right.
But
it happens.
yeah.
Okay.
Okay, let's jump into, no more questions. A1, let's jump into A2. Okay, A2 says prior to closing, seller will or will not remove lease fixtures covered by the fixture lease that the buyer does not assume. Seller will repair any damage to the property caused by any removal. Notice any lease fixtures remaining in the property are subject to the right of the lessor under the fixture lease. So 2 is just talking about if the seller's going to keep it on there or remove it, pretty much. If it's removed, they got to repair any damage. The seller has to repair that. And that last sentence there, when you look at it, any lease fixtures remaining in the property is still subject to the rights of the lessor. So the way I see that, if you don't pay, let's say the buyer assumes that everything happens and 6 months later you don't pay, then whatever rights the lessor has on that fixture lease, it's officially like they come and remove it, they sue you, whatever, all those things are still in play for that new buyer that assumed it. So they're telling you, hey, you're subject to the rights of the lessor, whatever that is, in that assumption, you are subject to that. It seems like almost, not needed to say it, but it is on this agreement saying, hey, you are subject to those rights or whatever they do for that particular piece of equipment or fixture lease. Let's jump into B. B, delivery of the fixture leases. All right, now you have one of 3 options. You should only pick one of those. The first one is, hey, buyer has received a copy of all fixture leases, right? This section almost reminds me of the seller's disclosure, right? So meaning that if I'm starting this whole process and prior to execution, buyer has received all copies of the fixture leases and agreed to assume, that's prior to execution, you would check off number 1. They have received the lease. Okay. 2, buyer has not received a copy of the lease. Buyer has agreed to assume the lease. Seller now provides a copy of the fixture lease within 5 days after the effective date. Buyer may terminate the contract within 7 days after the date the buyer receives it, similar to the seller's disclosure, right? So I say that to say, you should be 1 or 2 most likely. Hey, we executed this and we didn't get the copy of the lease, or we executed this and we received the copy of the lease prior to execution. Everybody still with me there? And if you received it prior to, and you check off block 1, you don't get the additional 7 days automatically to back out of this contract. Same little situation, same concept. So if you are on whatever side you're on, let's say you're on the buyer side and you don't have the lease, then you check off number 2. Okay. because whenever you do get the lease, you automatically give your buyer additional 7 days to terminate the contract and get their earnest money back. That's what you're doing. Okay, everybody with me? And then the third one, 3, which, not common, but can happen. I'm being told. I've never seen this, but I guess they got it down there because some type of oral agreement exists between some type of lessor and the lease, and they got some oral agreement, and now you're basically capturing what the oral agreement is between that lease lessor and the lease, and you're trying to capture it in those terms in section 3. If it's just an oral agreement between somebody, I think that's almost like buyer beware type situation. Not sure if I would proceed forward with that, but in the event it does, this is what that section is all about. B3. Okay. Any questions about that one? Seems pretty weird to have an oral agreement on a lease, doesn't it? But I'm sure they got it there for a certain situation because it has happened. All right. And then C there says at closing, there will be no liens or security interests against lease fixtures, which will not be satisfied outside of the sales proceeds, except for lease fixtures covered by the lease fixture buyer agrees to assume. And simply, I said, if the seller owes money on a lease and they didn't disclose it, title cannot close with hidden fees. Okay. So if there's fees that they didn't disclose for whatever reason, it's basically saying title can't close this deal unless it's on the sales proceeds and all this other stuff. Right. Questions about that? All right. No, the seller and buyer should consult with the lessor and their attorneys regarding assignments, assumptions, and terminations. Of course, you got to sign this, right? You got to sign this to make it valid by both buyer and seller. But let's get into some real world scenarios. Scenario number 1, solar panels. Buyer assumes the lease 3 days before closing. Solar panel company says buyer does not qualify. You're 3 days to close, and the solar panel company says buyer does not qualify for the assumption. Don't answer, George. What happens, y'all? That's a real question. Unmute yourself. Hello, I got crickets. Come on, Carmelo.
Those solar panels got to be paid off.
They gotta be paid off.
Seller-
Oh,
Either the seller got to eat it or that deal going to die.
but they're a lease. The seller didn't sign anything to pay them off ever. The
It's a
deal
lien
got
on
them.
it.
Okay, that is an option. That is something that can happen. What else?
They have to be removed.
Could be removed, and the seller takes them to some other place. All right. We got contract problems. We got a contract problem, right? Parties might have to renegotiate something. Seller needs to remove the panels, like Stephanie said. Closing probably is going to be delayed. The walkaway or the takeaway point of this is to always have the buyer pre-qualified with the solar panel as soon as possible. Do not wait. This is not one of those things if you're on either side of this, if you're on the listing side of it or the buyer side of it, everybody needs to jump in and make sure that the buyer can get qualified in a very fast, prompt order manner. Right. So stress that with your buyers that, hey, look, if we're going to do this, I've seen sometime because of the market sometime where we try and get all this stuff done even before entering contract. Right. It can happen. Okay. But that's the takeaway point. Make sure your buyer get pre-qualified as soon as possible.
Hey,
Yes, ma'am.
Ben.
1 second. I'm coming right back to you, Carla.
Both have your own account, and you're not about to run her credit. No.
Oh, you're going to have to. You'll have to in this situation.
And then I'm print.
It's going to affect you. That's some of the downfalls of trying to assume a lease of a solar panel. All those things still take precedence, but they chose to go in contract with this property, that's what they're going to have to do. Carla, what you got?
So can you add, I know it's not recommended, but maybe going to special provisions, add language in case the buyer does not qualify, they have an option out just like the third party amendment does?
I wouldn't advise that because we could be practicing law with that statement.
So how can we, I mean, this can be an option, which to me makes no sense. If they qualify for a mortgage, why would they not qualify? But if in that kind of scenario, what can we do for the buyer other than just have him pre-qualify right away? I mean, if they don't, they should have options. And right now it's like we're not having any.
Yeah. So the form, the reason I sat there and say you would not be able to do that in special provisions because the form itself is made by TREC already to address that concern. And so if the buyer didn't qualify, it would be like anything else. Either the seller would have to sit there and say, hey, I'm going to take them with me and I'm going to use them at my next location, or the deal's going to die pretty much. All right. In this situation, that's probably your only really two options. So no, I would not put anything in special provisions because there is a form that TREC has on this, and you could be practicing law on that.
I'm just talking about, you know, I mean, finding a way to protect their earnest money in case that they don't come to terms. So that way, you know, I mean, pretty much.
This is the document that TREC has that addresses that. And these are the provisions that they're giving us to work with.
But it doesn't say anything that if they don't come to terms, I mean, the buyer has a right to terminate and get their earnest money back.
Well, it has that if the B2 has that they can get their earnest money back after they get the lease or whatever, that wasn't term. But I know what you're saying. In this scenario, 3 days prior to closing,
Yeah.
nah, they wouldn't have it. Yeah,
So that's the only comment. I was just thinking about that, like, okay, there's really is a risk. I mean, you're just going with a risk, which I doubt that will be the case if they qualify for a mortgage. However, things can happen. So there's just no way to protect the buyer.
It is a risk that the buyer assumes when they start to try and assume a lease. It is a risk that is there. And let's go to another one.
I have a question.
Yes, ma'am.
I have a question specifically about this form. Who is presenting this form? Is it the seller's agent or the buyer's agent? Is it something like the HOA form that the buyer is supposed to fill out? It's up to the buyer's agent to fill this out, or is it attached on the MLS from the seller's agent?
I feel as though this is going to be a form that should be initiated by the buyer side with communication with the listing agent. Maybe the listing agent has some provisions inside the confidential remarks that would help you fill this out if they were smart. If I was doing this and I had some fixture lease that was on my listing, I would make sure they were able to fill this out to let everybody know what the situation is. But at the end of the day, like who's supposed to be filling out? It's not really a question of that. It just it has to be done.
Yeah. And I'm thinking if it were me and I was the listing agent, I would be posting this on my attachments on MLS, but not filling it out, but guiding them that needs to be filled out.
And that's the reason we do this training, to look at it from both sides, you know, from the listing side, from the buyer side. So if you are in a situation, you should be looking at, hey, well, these are things I should do. And if you're on the buyer side, these are things I should be doing as well. So yeah, definitely. But to say who's supposed to, that's a hard one. It has to get.
I think it will be beneficial for the listing as well, especially if they know if there's going to be an assumption and there's going to be a fee associated with the loan transition, the admin fee. I think it will be beneficial to have at least that information, and that can be explained that this is the fee. It can be negotiated, of course, but I like to know that, like, if this is something I have to present to my buyer and it's not up in limbo, how much this is going to cost.
But Carly, you're speaking from a perspective of like, hey,
Buyer.
all ages are equal and all ages are going to do something right. All ages are doing training. All ages are doing, and you got to take it from a perspective that that's not the case. And you got to take it from a perspective. And if it was you, yeah, you would do that. But in the event it's not, you got to be straight. You got to know how to construct this and how to navigate it. Hey, go ahead, George.
A lot of times the buyer has met the minimum standard in every category: minimum credit score, minimum debt to income ratio, minimum amount of money for income. So just because they're approved to buy a house don't mean they're also approved to get the solar panels or the water softener or the whatever. They may be treading the line very close. I've seen a situation where the seller wanted to sell the refrigerator for $500 on the non-realty items. That $500 took them over the debt income and they couldn't buy it till we figured something out. So never forget, your
Good point.
buyer might be on the line.
Good point. Thanks for sharing. All right. Okay. Let's go to the next scenario. I think people are getting something out of this today, huh? All right. Scenario 2, buyer didn't review the lease thoroughly, had a terrible buyer's agent, right? Buyer signed the assumption. After closing, realized there's a 22-year remaining lease requirement, $210 monthly payment, 3% annual escalation. Can they cancel now? We got no in the room. Anybody say differently?
I would say it depends on what this form says and how they filled it out.
Check out number 2.
Well, true, but they've already executed. There's pretty much no way. My point to this is always deliver the lease early and advise a review. If you're on the buyer side of this, I want you to really review it, get the lease. And when you get the lease, exercise B2. If they found something they didn't like, don't let those 7 days go past it, and make sure you're doing what you're supposed to be doing and not being negligent with your buyer. Okay. That's my whole point to this. But if it's past those 7 days and we're not closed, but almost to closing, they kind of stuck like Chuck because they had 7 days to back out. Okay. All right. Seller says it will be paid off at closing. It's not leased. It's finance. There's a UCC filing. What do we do then? It's not a lease. Any takers on this one?
You said
No.
you said that they're paying it off.
It's not a lease. It will be paid off.
Then we don't need this form.
You let
Totally different issue. This form is for lease fixtures only, not finance fixtures or paid off at closing. Huge, big difference. What we're finding here, the reason I put that on there is because sometimes people are trying to use this form when things are going to be paid off at closing or they've already been paid off. This is not the form for it. That's not what this is for. That's a totally different thing. And we'll have a different session for that. But I just want to make sure we're clear on that. This is not for that.
Doesn't it then come like a title?
Yeah, that's a whole different thing. We're not going to get into that today. But I just want to make sure the clear distinction. This is only for leased fixtures only. Okay. If this was scenario, yeah, there's other things you need to do for that. And that'll be, we'll keep that one for next Friday forums. Okay. All righty. Any other scenarios you guys want to talk about or throw out there or something like that to bring this to a close?
What are you using?
I don't know what UCC means. It's something against the house.
For commercial call.
Yeah, something against the house that's identified on the title company that has a UCC1. The solar panel says, okay, hey, we got a UCC1 code on here and it's being financed. And that's how the title company knows that, hey, we got to make sure to pay it or not pay it. Yep. All righty, y'all. This is it. Short and sweet. Not very long today. They got 2 for 1 today. And I gave you another one this morning. I think the other one was about the withdrawal of a counteroffer or offer. Okay. Thanks for being here. Appreciate you.
Thank you.
Later, man.
Oh my God.
Thank you.